Hello everybody, I'm Preeti Lakhera, Assistant Professor Law, National Law University, Delhi. Welcome to the MOOCs program on Information and Communication Technology. Now, I hope you have been learning a lot in these modules throughout this module we are teaching. Today we are going to discuss the module on direct taxation aspects of e-commerce taxation. Now, I'm going to start with what are the main objectives of this module. First, I'm going to talk about the concept of the digital economy. What are the difficulties of identifying the taxable event in the digital economy? How the application of the basic principles of direct taxation in the digital world done? And what are the measures being taken to tackle the application of these principles in the digital economy? Or are we creating new principles thereon? Now, I'm going to start with talking about what exactly is the e-commerce taxation talking about. Now, the e-commerce world is an ecosystem where the business transactions and relations can be facilitated more expeditiously in comparison to the physical environment. Now, to state the most obvious, most of the companies, if they want to have a viable business model in today's economy, they need to have an e-commerce platform attached to them. Now, obviously people are fastly revolving towards this e-commerce economy. They are buying things, they are downloading services here. So this is an economy which is creating a lot of revenue stream. So it becomes very, very imperative for the government and the revenue department to tax this revenue stream which is coming. Now, to start with the debate here, now I want to familiarize you with how the transactions are done in this economy and what are the drawbacks and what are the strengths of this economy. The strengths are obviously you have speed here, you have anonymity here, and the drawbacks are that in this economy in the first place that somewhere down the line you will not be able to track the people who are entering into this transaction. So connecting the transaction to a particular physical environment is going to become a very tough task to us. Now, I'm going to start with the meaning of the electronic commerce, and if you look at the meaning of the electronic commerce, it's commonly written as e-commerce as the trading or facilitation of trading in products and servicing using computer networks such as the internet or online social networks. The electronic commerce draws on technologies such as mobile commerce, electronic fund transfer, supply chain management, etc. Now, some of the examples I can just give you where the e-commerce business may be employed is online shopping websites, participating in marketplaces where the process of the third party and business to consumer or consumer to consumer sales are done online, business to business buying and selling, gathering and using the demographic data through the web contacts and the social media. So there's numerous examples where you can say the online platform or the digital technologies are being used to undergo commercial transactions. Now talking about the digital economy, just to take the conversation forward from here. Now, we are talking about an economy where digital computing technologies are being used to earn revenue out of them. So, we are also talking about something which we call as the internet economy or the new world economy. Now, as we have been doing various studies by various groups, this economy is growing at a very fast pace because this is an economy which makes transactions very convenient. This is an economy which can make you do things at a very fast pace. So it becomes very, very important that everybody starts accessing this economy at one point as the other. And you have people who are traveling across the globe, they are entering into transactions, contractual arrangements. They definitely want to use this economy when they have their intercourse and transactions among themselves. Now, I'm going to start with the legal framework now because I've given you a basic background about what is the digital economy and what is the e-commerce environment. Now, I'm going to start talking about how do you identify the taxable event for the physical environment within the logic of the Income Tax Act of 1961. So, we basically have two principles there. One is the source principle, something which you can find when you read the fine-tuned language of section 5 read with Section 9 of the Income Tax Act of 1961. And this is talking about where exactly the income is accruing. So we look at some connecting factors. Like for example, if you look at Section 9, which is talking about the income has deemed to accrue within the territory of India, we are talking about connecting factors like business connection, royalty, interest payments, and in the alternative, we have the residence principle of taxation. Now, according to the IT Act of 1961, Section 5, a person who is resident in India, his worldwide income is amenable to the Indian taxable jurisdiction. Now, for the non-resident, it's the income which he has accrued in India. So, for the purpose of the residence taxation, it becomes important that you should be coming within the language of Section 6, which is coming out with various parameters. For instance, you have to be staying in India for a period of 183 days before we can say that you are actually a resident Indian. And talking about the corporate world, if you look at Section 6, Clause 3, it recently introduced the test of the place of effective management. So, if the company place of effective management is located in India, only then it is said to be resident in India. And obviously, we are talking about situations where the company has not been registered in India. Otherwise, it evidently is a company which is resident in India. Now, going forward with this is a basic domestic framework I was talking about. Let's talk about the international taxation legal framework. Now, if you look at the international taxation legal framework, primarily it was created by influential international organizations. And the reason was that they wanted to solve the problem of double taxation. So the same income which is being accrued to the same person should not be taxed by two jurisdictions. So it should not be a situation where a person who is an Indian resident but who earns some income in the US, he actually is amenable to the tax jurisdiction for the same amount of income in India and US also, because that is going to lead to a problem of double taxation. And because of this tax problem, people will not be having an incentive to move across the borders, take their money across the borders. So in order to solve these problems of double taxation, you have an international taxation legal framework. And if you look at powerful international organizations like the OECD, the Organization for Economic Cooperation and Development, which is backed by the influential G20 countries group, they have come up with this Model Tax Convention on Income and Capital in 1963. So this is a document which is like giving you a blueprint as to how you're going to solve this issue of sharing of the tax revenues when two countries are going to have the tax jurisdiction on the same amount of income or the same person as such. And on the same line, from 1980s, you have the UN Convention for this purposes only, which is talking about the model tax treaty between the developed and the developing country, which has been recently updated till 2011. Now, following this, you have in India various DTAAs, which are the double taxation avoidance agreements. So all these documents are India negotiating with different countries and entering into a conversation as to how the tax will be divided when there is going to be a conflict of interest and where there is going to be the jurisdiction of both the countries on the same tax which they want to take a tax on. So just see the international taxation legal framework. You're going to look at the OECD convention, you're going to look at the UN convention. For India specifically, you're going to look at the Income Tax Act of 1961, which is going to give you the domestic legal framework. And just to mention here, you also have to look at Section 90 of the Income Tax Act of 1961, which is making it clear that the Indian government, they can actually enter into negotiation with different countries across the globe and negotiate tax treaties with them, because of which we have the DTAs which are coming into the picture.